thinking I should do it today, but in fact, we'll play it by the ear. I made a mistake, and I'm relieved that we have enough time. That's the main thing. So any questions, comments, and so far what we have discussed before we get into the remaining ideas about common but differential responsibilities and special capacities and things like that, principle. Before I get to, in fact, yesterday we only did Kyoto Protocol. So 3.1, before I get to 3.2 was why necessary, differentiation, etc. So any questions, any comments? Any personal comments? Like my socks, some of you might find my socks very torn, particularly those who sometimes sit this side. And I can tell you why socks are torn, because I tear them. With a Julius Caesar, I cut them. Why do I cut them? Because my left leg begins to swell at 2-point-something temperature, the effect of climate change, and becomes big and big and big. And then, unless I hoist it up when I get home or get wherever, with 2 or 3 pillows, the swelling continues. I've been to many doctors, including, sorry about that, I can't feminize it. It's already feminized in a perverse way, witch doctors. So I've been to everywhere to find out why this left leg swells. So in order to not to have it too tight, I tear the socks. That's why my socks are always torn. And that's how I discovered that there was a specialist from Harvard in Chandivala Extension of Sardarji, and he said, "You come to the right place, sir. I've just come from Harvard. I'm a poderist. Poderist is a foot doctor. But what is important is I'm not ordinary poderist. I'm a left foot poderist. So I've gone to all the experts I can, and I still bore with majesty, with great aplomb, my torn socks." We have now been told that Sardarji jokes are no longer prohibited. So I can tell you one about socks. Of course, Gyani Zail Singh, when he was my visitor at Delhi University, he used to himself tell me a lot of Sardarji jokes. So Sardarji have no objection to this, most of them. Some of them are sensitive and go to Supreme Court. And for a change, the Supreme Court refused to interfere. For a change. They did not practice what I call demonstrance. It exhibited self-restraint. There is a story about socks. There was a man in Nehru's cabinet called Sardar Baldev Singh. And Nehru was very sensitive. He was a Lee-white fellow, Lee-livered fellow. And he didn't like badly dressed people and people who had some kind of order. So he used to carry a perfume and spray on his colleagues. The Prime Minister do very many fancy things. So Sardarji said, Nehru said, "Sardarji, you don't smell very well. What is the matter?" I said, "No, don't worry, sir. This is the file. It's supposed to discuss it." Nehru continued, and I said, "What is it? You have to tell me." Excuse me. And he said, "It may be my socks may be emitting this smell." So he said, "You change it every day. You can't come to me. After all, not for nothing in my requirements of India. That's my addition." Next day, week or day after, the smell continued. He said, "Sardarji, I told you several times, why don't you change it?" I said, "I've changed my socks. Where is the smell coming from?" And the Sardar Baldev Singh is supposed to say, "It is coming from my pocket." And he took out the old socks. So he no doubt followed the Prime Minister and changed his socks. But he put the older socks into his pockets. I often do that myself. I think he's a great guru of mine. And Gandhi Singh came one day when, as a visitor, came unannounced. And he said, I want to talk with your students and colleagues. I said, I didn't speak any other language than Gurumukhi, which I don't speak. So he said, Nahi, gal karna hai. You want to talk. So I took him to the sports stadium. He had uncanny habit of holding hands. He held my hand and he said, and I asked some teachers and students to please come because visitors suddenly come. And Gandhi Singh wanted to speak. I said, speak, sir, words of wisdom, Chancellor. So I think he said, Jab se banda mane, this chap has become विश्वविद्यालय का कुलपति बना है, तब से ये विश्वविद्यालय की प्रगति हो गई है. Pragati is gone beyond in the stratosphere. He meant pragati, I don't know. He meant progress. So I'm always a learning mechanism. Progress very often means pragati or durgati, bad development, maldevelopment. So I think what we're discussing is pragati, is Paris a document of pragati or pargati, Paris Agreement? That's the main question that we have to discuss. That's how Gandhiji comes in. It is difficult because it depends on how you read the Paris document. There is no one way of reading it. For example, if you're a woman, you would ask what Paris Agreement says to us, about human rights of women. If you're disabled, you would ask the same question. If you are in the imminence of being your country going under the sea, a small island developing state, SIDS, then you would say, आपने तो समझौता कर लिया, you agreed at Paris. Nobody ever notices this small island. And there are thousands of them in the Pacific, but not only in Pacific. Our Andaman Nicobar Island, and many island states which are sovereign. And I remember, I don't very often do that, but I testified before the Australian Senate Select Committee. And the United Nations, or Australia was going to propose to the United Nations to call these island states, at that time it was very new, by a term called Micromini States. And I said, you can't use the word Micromini States. States, but they can't afford to maintain legations like Nauru. Nauru can, but Tahiti can't. They're very small islands. Solomon Islands, 1,000 islands. So I said, you can ask for associate statehood. You are members of the UN, but you are not. You have a right to vote, but you can't maintain a legation because it's very far New York, and you go from Tahiti to New York is a long journey. So those who wanted, ultimately after a decade or so, they became associate members of the UN, associated states. So if you're a small islander, you would definitely think of tomorrow you are going to sink. And you look at Paris Agreement and say, what is there in for me? So you study by Jane McAdams, which you must read, or you might have read already. Jane has proposed, before the treaty was made, we don't want a multilateral treaty like Paris. We don't want a framework convention like Paris. We want an answer to our problems. The answer is blowing in the wind, that won't do. The immediate answer, our islands are sinking. And the Americans exploded large amount of nuclear weapons on these islands and destroyed. What the connection between nuclear weapons and climate change is a very important issue. And literature does not face up to it. So they renamed one island as Bikini Atoll, small island. Now, you would object to the name. It can't be Bikini Island, you say. But Bikini Island was virtually destroyed. It's a small thing. So I think there is a, depending on where you are and what you want, you'd either, if you're a developed country, you would welcome Paris Convention. Javadekar, developing country, India, regional powers, welcome, Japan, welcome. But if you're a small state in the imminent threat of disappearance, you would say, I don't get any solution to my problems here. So it depends on where you are situated. Interpretation is a matter of general principles of situated understanding. Show me any interpretation which transcends the situation. Situation with emergency, situation with coalition government at center, situation with supermajority at the center, situation with first generation national leaders, Nehru, Prasad, Pant, Ambedkar, who made the constitution, they ruled India, and situation with third or fourth generation of leaders now leading India. So have you ever wondered why the Supreme Court did not even squeak accepting right to property? Why did not even whisper until 1967? It passed all amendments. In 1967, it passed all amendments. But they began to turn. They're now second generation with Sastry and others. And they began to assert themselves. If you study the SAL, sometimes the SAL, social action litigation, flourishes most when coalition government is in center, not when supermajorities are in center. So everything is, interpretation is situated, for good or bad. And you must remember that our interpretation is also situated, whether women or small-handed or disabled. You will see the situation, the overall context that way. There is no help for it. It's a bad thing. Now we think interpretation is hegemonic, it is single focus, it is unipolar. The court has said this, therefore it should work. Any executive has said, the parliament has spoken. That's not how things work. All right, that's not my subject. So, if you look at we will not discuss the whole of Paris, we'll discuss some aspects of it, because they are saying, because we don't have time. First look at the idea of differentiation, or in the human right. Differentiation is the technical term. Common but different responsibilities. The word different is what is common and what is different. What is common is that all states, international organizations and peoples must combat the menace of climate change, must contribute to prevention of degradation of climatic conditions. That is common to all. What is then different? Differential are the responsibilities that people have. States have, people have, international organizations have. International organizations do not possess any territory, like UN. UN is a super state, but it's located in New York, courtesy the American people. Tomorrow they could say, we don't want the UN. Kurt Waldheim, before he was suspected of Nazi connection, he was Secretary General of the UN. As a European, he didn't want the UN to be located in New York. He tried his damnedest best to shift it to Vienna. And he was partially successful. Half of the UN today is in Vienna. My Commission on Crime Prevention and Treatment of Offenders was shifted from New York to Vienna, for example. That's how I understood Wittgenstein's Vienna, by going there. So it's very important to understand that institutions are not states. They might be super states. They have no sovereignty, they have no people, they have no territory. But they are international organizations, and United Nations and the specialized agencies, other, right up to networks, institution networks, like Davos, the network. BRICS may be on its way from becoming a network to an institution. It depends on how we analyze the situation. Okay? So, the obligations will be differential. And differentiation is a principle of human rights and Anthropocene justice. What is common also is the principle of Anthropocene justice, but what is different is also, and when you have a full principle, common but differentiated responsibility plus some permitted capacity, whatever capacity, the correct name is RC, respective capabilities. So the respective capacities make a difference. So you have got, you should not talk about only CBDR, common but differentiated responsibility. You must talk of CBDR plus RC, respective capacities. The 5 words into 3, 6 words into 3, 4. So, and Lavanya Rajmani has written a book, as I said, on common but differentiated principles, and you must find time to look at some of it. She's also written a number of articles which you must read. And you might want to call her sometime to Nalsa, perhaps, because she's right in Delhi. And she can speak to CDBR and RC with some assurance and greater fluency than me. So welcome her sometime. See, mind you, she does not know that I'm saying this. You can invite her in her own capacity. She one of the few third world global south scholars, one of the very few international law scholars to have focused on differentiation. She doesn't focus in terms of justice, which I do. She focuses in terms of human rights. And that's the difference between human rights and justice, which we'll discuss a period of time. But if you take my distinction between human rights and justice seriously, you can have all the rights, but you may not be all right. You can have all the rights in the world, but you may not be all right. Well-being is not a human right. There is no human right to well-being. And you might have no rights at all, and yet you might be super fine, you might have well-being. So, the connection between right, if you identify justice as well-being, a life worth living, a good life. You can live a good life, some say, without rights. And some say you can live a good life only with rights. There are different possibilities. I don't have particular view just now on that. So, C focuses mainly on human rights as enacted by United Nations. She's not worried about idea of justice. But she's very good in what she does, notwithstanding this caveat. So I will not try to discuss, but here there are three issues in studying Paris Agreement. Now one is question of legal form. It's again differentiation. How does the Paris Convention structure its obligations? And what are the norm addresses? A very important question when you read any law, but certainly Paris Convention, to whom does the law obligations apply? And that's a very important. What are the norm addresses? To whom is the law norm addressed? To people at large, to states, to international organizations, to corporations. And none of the norms, as I'll say later, is addressed to global corporations. That's a very big minus in the Paris Convention. A very big minus point, to my belief, in international and national law. Obligation, of course, to murder, obligation not to murder, is in IPC, and Adani or Ambani who actually murders is liable to be tried and found guilty. But multinational corporations are under jurisdiction of no one. So what do we do? We could not even extradite Warren Anderson in Bhopal. In my case, I went to the first anniversary. I go to every anniversary. Now I don't go because I price of health. But the first or second anniversary, they all asked me to light a torch to the effigy of Warren Anderson. Neither any effigy of me have been burned so far, nor have I burnt anybody's effigy. I consider it symbolic violence. That's a different matter. I could not burn the effigy of Warren Anderson with his matchbox and candle and everything. I tried, but it didn't burn. So there is a problem in Paris Convention. It is, the norm addresses include all but exclude multinationals. We come to that effect. That's why I make a distinction between having rights and justice. Who polluted the planet? The Westinghouse, the General Electric Corporation, the Union Carbide of the world, the Monsantos of the world, the Syngetas of the world, all these corporations which are enjoying de facto and de jure impunity. They are not liable under national law, they are not liable under international law. It seems to me Paris Convention is only made possible by exclusion of multinationals. Most international treaties are made possible only by certain exclusions. And therefore, it would not have been possible to get America or Western countries together with southern countries on a climate change convention if you had raised the subject matter of whether corporations are in or out. So they are not there. Unless they decide that it binds them, which is rarely the case. So it is, one is the question of legal form, who are the normal districts. One is the question of differentiation. The third relates to adaptation and mitigation process. Adaptation to climate change. What are the new technologies that you will? Wind energy, alternative energy sources, alternative to fossil fuels, right? How do you adapt yourself to climate change? What is the theory of just emissions, for example? And mitigation. What do you do when some countries or nations are immediate victims of climate change? who will bear the cost of looking after them? How would you deal with climate refugees? I want to talk about, I hope I get a chance to lay out before you what numbers are, and they are staggering, eventually. They are really staggering. You can forget about refugee asylum seekers from Syria. But don't forget them, please remember them. But the magnitude of people who will come, the whole Bangladesh will come to India or Nepal in 2030 or 40. So it will sink, sea temperatures are rising. What about 1,000 Solomon Islands? Where will the people go? They will come to some part of the world. And you say, no, America first, India first, then there's no hope for them. Where do they go? It will become another wave of boat peoples. You heard of boat peoples who are refugees, but who spend their whole life on the boats from Vietnam. They could not be, were not accepted by anybody. So what will UNHRC, UNHRC Refugee Commission do? It will be recast. So it's a problem of systemic change in United Nations itself. Does the Paris Convention address this question of climate refugees? No doubt it talks about adoption. There are three problems therefore that are related. Differentiation, question of legal form, who are the norm addresses, the question of, and mind you, it's a framework treaty, so it is a bit of directive principles. It's like our constitution. Indians have no problem, Indian lawyers. They say shall, they say may, that kind of thing. We should have no problem with. And it's these fellows who have problems out there, who don't have directive principles in the constitution. But we know that certain directives will languish. They will never be eligible for state action. They are there to adorn the constitution. What T.T. Krishnamacharya said, at the making of the constitution, T.T.K. said, the whole chapter on directive principle, Ambedkar called it social revolution. And he said, yes, Mr. Ambedkar, if you think it's a social revolution, I agree, but it's social revolution in the dustbin. He regarded part 4 as dustbin. So it's possible. So we know the Paris Convention is somewhat like that, in a sense, a revolutionary dustbin. It depends on how you read it. That's all I don't want to tell you how to read it. But you should read it in terms of differentiation principle. You should read it in terms of, don't skip it, in terms of adaptation and mitigation, and you should read it in terms of human rights. That's the idea. You should not skip that three core ideas when you read any environmental law convention, or certainly not the Paris Convention. I should hurry. Paris Convention proposes COPs, various conference of parties that will take place. Paris Convention envisages an post-development agenda which will be adopted between now and 2030. The work has already begun. So I get queries from various universities, my students, erstwhile students, like to me, very kind of them. We want to start, we have this law and development program. And I'm vastly amused, because here is UN developing what is called post-development. And we think it's educational innovation to talk of law and development. Actually, it should be the other way around. We should be thinking, we should be ahead of UN in thinking. We should not be guided by UN in thinking. So what is post-development? I said a lot in the first general address on Sunday. I won't repeat it. But post-development in the context of climate change at least means one thing, that you will follow a theory of just emissions. You must minimize the reliance on carbon economy, on fossil fuels. And you means everybody, states, industrial organizations, people at large, multinationals question mark, but everybody. So it is this particular thing that you have to bear in mind. So essentially, let's look at my notes. I can't read this. So that is the first thing. Now, in general, one should immediately recognize that the problem of relating human rights to climate change is immense. It is not a simple matter of reiterating human rights, this or that norm or standard. It's a question of adapting and mitigating human rights and readjusting them to the new threat. That's why I say you must not merely throw away, think out of the box, but you must smash the box. Unless you smash the box, you don't realize how much work ahead of you lies. It's not a question of tinkering with this or that human right. But let us look carefully first at the question of form or differentiation. And in Paris Agreement, your Christiana Woggett's small article, I've given you very small articles in Paris Agreement on differentiation and entitled Differentiation in Paris Agreement. Have you read it? It's only 8 pages. Anybody? Not even curious to see what it contains? It's now 4th day, so it might be time to call on you if you've read it. If you've not read it, no problems. I cover it to the best of my ability. Or to the worst of my ability. I don't know where that phrase comes, best of my ability. There was a great German thinker called Friedrich Nietzsche, who spoke about slave morality. Slave morality of slavery. So when the master says to the slave says, sir, I'll do the best of my ability. That's the origins, I think, of the phrase, best of my ability. But I'll do it to the worst of my disability, okay? Worst of my disability is the right phrase. Not best of my ability. You want to avoid slave morality. Now what does the first threshold where you stumble, I stumble at least, I invite you to co-stumble, is whether there is an international customary human right to development earlier, in any sense. Second related question, if it is there, if there is such a core right, basic right of peoples and states to develop, and there is a whole declaration on the right to development, which are only 8 articles, 1985, which I urge you to read, even if you are not international lawyers. Because here lives a man who was the judge of the Supreme Court, Justice K. Ramaswamy, who on the Supreme Court with the fellow judges developed the right to development in 15 of his judgments. The Indian Supreme Court has implemented the right to development and developed it further in Indian context. Those who are studying Constitution or international law should study Brother Ramaswamy's judgments, including the landmark judgment in Samta's case. Samta was an organization of 5th and 6th scheduled peoples. And you must read that carefully. And how wonderful is the development. And he seems to think that right to development is an integral part of international law, such that under Article 51, it is binding on the Indian Supreme Court. And that's why he developed it. So he thinks the part of customary international law, which is an extremely radical shift or proposition. Hardboiled international lawyers doubt it. Because right to development suddenly appeared on the scene. It is the work of 5 jurists who wrote that instrument and pushed it through General Assembly. And General Assembly said yes. You heard of Emperor Caligula, by any chance? The Roman emperor. And he nominated his horse as a senator. A horse as a senator. Now you question that Roman people, like our people, like to take an oath of office. Now how does a horse take an oath of office? The horse was trained to lift his foot. I solemnly swear. And he swore to the then Roman constitution. So, this was a bootstrap of impossibility in law. A horse become a senator, the idea is impossible. An animal, if you're not an animal rights person, we're only rational animals who can become our legislators, our judges. Non-human animal persons cannot become our judges or legislators or appeasers. You ever heard a squirrel become a judge, Chief Justice of India? Or a rabbit become a legislator? Now I'm not going to question why not, because most people do not know much about animal rights. You know, Ananta, you know, and you might have a different view, but most people do not have. So there is a question. So what is international law in this subject? Now I want to make clear two lines of argument. One line of argument is a part of customary international law because it has been reiterated any number of times by the UN, and UN must be taken seriously. And all the preambles incorporate right to develop, a reference, a recital to right to development. So even if it was not a part of law earlier, by constant reiteration, like the thesis, it has become a part of customary international law. Then the question is it a part of customary law in such a way? And Paris Convention has a recital which also refers to right to development. That's why I'm taking your time with it. So one view is that it has become part of customary. That's what Brother Ramaswamy also said in the Supreme Court with other judges. And the related question is, well, yeah, assume it is part of customary international law and therefore binding on states. Assume that. Is it such a norm? Does it provide norms of such a character that they cannot be departed from? What international lawyers call jus cogens, or peremptory norm of international law, peremptory norm, which you cannot even wriggle out of in a treaty. You have to agree. Genocide, for example, apartheid, are international jus cogens. You can't any longer. Or empires. You can't have an empire. Territorial integrity of a nation has to be preserved. There are certain jus peremptory norms which a treaty can't waive. So is right to development of such a character? Even if it's a part of international law, arguably, that is one side. The other side says to these two questions, no. So when similarly there is reference in preamble of the Paris Convention, lo and behold, to sustainable development. Now, is sustainable development a part of international law? Integral part? Has it become an integral part, so integral as to be a core human right? And we discussed the other day the notion of sustainable development, which to my mind at least does not make any sense. But that's my view, it may not be your view. It's certainly not the UN's view. It's certainly not Brundtland's view. And it is not the view of the international civil servants who have conferences on right to development. I was recently asked, I could go to Vienna, but I wrote a paper, should there be a treaty on right to development? So far it's a declaration. If you say the customary law, shall not qualify it. So I became the International Law Commission. Mine was the only contribution in that booklet that was published by somebody in Geneva, which outlined what a treaty may look like and why it is a bad idea. Which is my part, I couldn't help it. So that's a big mistake. Now, our author Voigt does not go into these aspects of whether Paris recitals are part of international law or not. I think Christiana assumes they are. But you should not, when you read, you should not assume that every recital in the preamble of the Paris Convention is necessarily a part of international law. You have to argue for and against before you take a position. Right? So, but she tells us of the ways in which CBDR and SC were discussed before Paris and after Paris. You know that. I don't want to take you there. But I want to give you, I'm going to two quotations. One is beginning with the worldwide categories of countries. This is developing, overdeveloping, are still relevant, etc. You got it? I shift it to the next page. The overall approach to differentiation is not premised on contribution to the problem alone, but on amalgamation of country-specific responsibilities, capabilities, and circumstances, which also services the purpose of the agreement in long-term goals. What do you make out of this? What do you make out of these two observations? Does it? Is it? Or is it, the CBDR, expressive of the right to development? A very million-dollar question. Is it use Kogan? Now, if you study with 85, nobody talked about climate change. Now, obviously, what Italian jurists call a famous phrase, Wilfredo Pareto, he was an economist and lawyer, and Wilfredo Pareto said in 19th century a fantastic phrase. He said this phrase, quote, contemporaneity of the non-contemporaneous. That which is not contemporary becomes contemporary. So it doesn't matter if it was 85, there was nothing contemporary like climate change. And we are in 2017 and there is climate change. So contemporaneity of the non-contemporaneous. Something like that. Will do. So we are dealing, is the Paris Convention dealing with what Pareto said 150 years ago? Can we apply this idea of climate change and climate justice, which is writ large on Paris Convention, can we apply it as a integral part of international law, such that binds nation states? And this is what Krishna said, I won't elaborate. Or is an alternate reading of Paris Convention possible? Making it more consistent with the principle that Conference of Parties enunciated in Kyoto Protocol, they did in Rio, they did in Durban, they did elsewhere. Is it possible to regard Paris Convention as a part of actually existing international law. Then we are talking. Because then we are talking of binding norm. Does what in Paris Convention enables you to say that there are binding norms? Everything from directive principle like this. That's a big, big question. And I have again quoted Prof. Oh, you don't have it? You shortly have it. The last quotation. No? Is an alternative possible? Listen again to what? That's what they say. Can you look at it? Can you look at it? Policy space. The agreement allows for evolution of policy space. Mind you, it's a framework agreement, and the function of framework agreement is to open up policy spaces in which states and international organizations can act and flourish. References to this principle are general in character and are not explicitly linked to any article of convention or annexes. Is it innovating? Is the Paris Convention innovating international law, or is it moving away? Are we in search of a new international law? Very big question of continuity and discontinuity, dialectic between continuity and discontinuity. The preamble and the Articles 2 and 2 and 4 signal that the Convention principle continues, CDPR RC continues to apply in a manner that is not static but open to change. The parties' obligations are thus responsive to an evolutionary understanding of accountability for climate change, considering parties constantly changing responsibility, etc. So, what do you make of Kristana? What alternative understanding of Paris Convention emerge? I don't like the expression, being a woman, being a feminist, hard law and soft law. But they are prevalent in international law. In fact, there is a conference in Africa, South Africa, which I could not go to, but I am settled and disengaged with responsibility of writing a paper. Hard and soft is a bad masculine distinction, male man's distinction. Hard, something is hard, excludes emotional reason, sentimental reason, which is also equally a form of reason. Sentimental reason is not reason, say the male philosophers. Sentimental reason, if a woman, you would say sentimental reason is also as much important as other kind of reason. When you go to public reason, when you go to judicial decisions, Mr. Justice Deepak Mishra was overcome by a nationalistic spirit and done by Justice Bannerman. The sentimental reason that you must all salute when the anthem is sung. Who would say no? Of course you must salute. What if I can't stand up? Then order of the Supreme Court, if you can't stand up, you're physically challenged, then you sit down. It took a lot of time, a lot of beating by the goons before the order came. And then their lordship issued a further corrigenda that you did not get up when in a picture, something, national anthem is sung, you don't need to get up. Why not? Where does the national emblem act say you do not get up, or get up, or not get up? Why? So his zeal for nationalism, patriotism, is a political passion that he expressed as a judge. I mean, a mistake to discount it altogether. My friend, the Vice Chancellor, has criticized it. It's been very aptly, but is criticized on the ground of, and many people, not he alone, भाई साहब आपने और ने भी किया है, on the ground as if Justice Deepak Mishra and Justice Bhanumati were speaking hard reason. They were not. They were engaging in political passion. And should judges engage in political passions is a very important question. So we don't even reach there. If we say reason is only male and hard, that's my short point. Reason can be emotional reason for action. And emotional reasons can be very, and I don't have time, but there's a very nice ethical philosopher or analytical called Annette Blair, B-L-A-I-R, with a whole book on sentimental reason. And the founder of economics, one of the founders, Western economics, Adam Smith, had a long article, long chapter, 3 chapters in his jurisprudence. Adam Smith lectured on jurisprudence. And there is a long essay or two on sentiments. Hard economics, but what are preferences that you maximize? Preferences are your own. You want a jean, or you want a sari, or you want a sarwal, or whatever, kameez, whatever you wear. I don't know what this word even. I don't remember. So your tastes determine your preference. And your preference determines the market, what they will produce and distribute. Or vice versa. If you go to Marks and Spencer's and things like that, obviously they will dictate what you choose. In other cases, they will be dictated by what you choose. So it's mela. So that's hard and soft I reject. But very often it is said, about Paris Convention, hard and soft I use. This big caveat, and you can read my paper I sent to Amitabh and I write it on South African people, which is half done. But it is not a question of merely of terms are very important, words we use are very important, but it's also a question not of hard versus soft law. The Upanism that I practice is more important is the question when hard law becomes soft, or hard law is softened and soft law becomes hard. When do directive principles then incorporated into fundamental rights and become hard law? The soft law in part 4, hard law in part 3. If you must use these terms, I hate them. If you want to use these terms, because that's convention. So in Iraq war, the law of self-defense, which was a hard law, was softened by the superpowers and even by the UN. So they could wage a war against Saddam Hussein. Hard law became soft. Customary law of self-defense did not allow Iraq invasion. In fact, I held a tribunal. I was in England, I held a tribunal against the Iraq war and prosecuting Mr. Blair, Tony Blair, for war crimes. And we pursued the matter for a long time. We failed, but it was worth doing it. Because we heard the Iraqi prisoners, how they were tortured, Iraqi civilians, how their collateral damage was suffered and all that. So, if Paris Agreement is to be characterized as soft, as she does, the question is, how may you harden it? And if it is already too hard, the question on the other side, how to soften it. So I'm interested in the second part level. Soft and hard distinction of itself does not interest me. But it might interest you, and the world is large enough to accommodate different emphases. So I don't insist on anything. This is my view, and I put it before you for whatever it's worth. So the question is here, what do you think? That's the question. It's your thinking that matters. Not my thinking it matters. I do regard Paris as hard law or soft law of becoming hard, a soft law that tries to become hard, a hard law that becomes tied to soft. That's the question. And I'm interested in your views when you read the Paris Convention. Maybe there will be an occasion where I will stop talking and you will start talking. Right? Because I would like to know what's going inside your mind. Doesn't matter. I present problems. I do some reading for you, but eventually I would like to grab you and your ideas. So please beware. Didn't say I didn't tell you that. Now, human rights. I think the preamble, the Paris Agreement, is amazing. Can you see? Climate change, it says, a common concern of mankind. No COP before Paris, including Kyoto Protocol, defined the word common in terms of concern of totality of human beings. It's a great advance. When you teach it or when you learn it, you appreciate it. It's a preamble, but it's a marvelous preamble. Climate change is a common concern, and its roots lie in a doctrine that Ambassador Pardo of Malta in 1967, I think, isn't it? When he declared in the UN General Assembly, the ambassador said, and he was from third world, all the facility contributions to international law are made by third world law. I'm founder of an association, I'm considered a grandfather of an association called TRADE, Third World Approach to International Law. Ram Anand and myself, our club, R.P. Anand and myself are clubbed together as Pranetas, the founders of the TRADE. And this is now the third generation of traders, those who follow the third world approach. The Ambassador Pardo said the following words. He said the phrase, he coined the phrase. He was a short man, but he was a long live in history kind of man. He said, there is something underlying all international law. It's a common heritage. At that time, feminism was not very fashionable. He said, coined the concept of common heritage of mankind. Now, man is male. Man includes one, but you have to be man. So I avoid the word, I say humankind. Women call it humankind. So we say common heritage of humankind. I had great difficulty, by the way, when I wrote the first edition of The Future of Human Rights, and Oxford said, I had coined the word "hupa," because the word human has man in it, and I didn't want to mess around man, and the person has son in it. So you can't get beyond and talk human rights, you are already caged in patriarchal ideology. And I wanted to say, I take the first two letters, so U and Pa. So I said Upara. And Oxford University Press said nothing doing. Nobody will understand it. So I have a footnote in my first edition. There are no immortal ambition to be in the Oxford Dictionary of New Words. Some people have that ambition. But I'm talking about human rights, but my publishers don't accept it, so what I say human rights. I'm really talking about human rights. So in a sense, this is an acknowledgement of human rights. Not human rights, you can say that like hard law and soft law, you can say that, but that's something in my mental furniture here, so I avoid it. So I say human rights are recognized. Common concern of humankind comes directly. Therefore, climate change is common concern. That phrase comes from common heritage of humankind. That phrase of Mr. Pardo in turn comes from the idea of equity. Law must be equitable. Law must be just. Law must be fair in order to be law. That is an old idea, ancient idea, and it's the principle of equity that stands recognized here. So you have to go layer after layer of this preamble assertion. I won't have done. And then parties should, when taking action to address CC, I call it climate change, CC, respect, promote and consider the respective obligations of human rights. Now the second part worries me again too. How did it get into the Paris Convention? The conventional UN language is not this. Conventional human rights language is not respect, promote and consider. Consider is a completely new. It's never been used by any instrument in the UN. What does it consider? That the first and likely person. Consider human rights obligations. So earlier there was in the UN a movement for respect, protection, promotion and compliance with human rights. This was UN language. So second part of this unknown. Sure, the first part, and the second is also unprecedented in the annals of UN, but in the wrong way. No doubt this phrase comes out of respect for the UN Human Rights Council. The UN Human Rights Council had passed 5 resolutions, and you must study them, I don't have the time, to link human rights with climate change, human rights with climate change. And in fact, some of the environmental agreements refer to that. I refer to that in it is started. I think I put them off. Would you take care of it? I think I put them off. Maybe somebody else. Still obvious is a useless notification. So it is very important to see the top wars within the UN. The United Nations system has many cells. Not all of them are sleeping cells. And this Human Rights Council is a new creation. It's a planting office of Human Rights Commission with which I work. And when they, the specialized body of the UN, when they say climate change must relate to human rights, the Paris Convention or any convention of UN cannot ignore it. You know Christmas tree? Everybody puts a little gift in hamper. You wrap it up and you put it, and then the Christmas comes and you open it, the children are happy hampers. So UN is like that. Everybody pushes some envelope. My stuff should be also there in climate change convention. UN security, the international civil servants have their own interests and strategies. FAO comes in, what's the impact of climate change, food, WHO comes in, what's the interest in health, somebody else comes in, everybody comes. In Hindi, kahawat, it says, sab bandar ke vyapari. Everybody comes in. So it's like a big mela, and you put in your interest. So this is why I think, but this is a very aggressive move in my opinion, to say human rights come in. On the other end, note this part, which again is very important. It says climate change influence will be felt most acutely by those segments of the population that are already vulnerable, owing to geography, gender, age, indigenous or minority status or disability. So this is very important to my mind. Not all human rights but some. So First Nations people, minority people, gender, old people, there's nobody old here, there's no old out there. Old people and age, my goodness, nobody ages. So people out there who belong to this particular constellation, where human rights are protected. Okay? So it is exclusive in linkages between climate change and human rights. It is selective. And the phrase, the word vulnerability is very critical. This is how you ought to read even the preamble very carefully. You don't, nice word in Hindi, gagraify. You don't read like a Tufan Express or Satabdi Express. You don't read as you run. You read slowly. Every word in law matters. Comma, punctuation. What made Gnani Palkha a superb lawyer was the ability to stumble at a word. He did not acknowledge that, but I say it on his behalf. Good lawyers are those beings who know the value of every word, the meanings of every word. Otherwise, they are lawyers, but not Chalta. I hope none of you will be Chalta lawyer. Good lawyers are people who study the text of the judgment, text of the legislation carefully before they say it. Right. So I think I would see, protect, prevent, punish, and respect. I would also say these were the earlier parts. I would have great difficulty with the second part. I would have difficulties with the third part because the age, I think children are coming in, old people are coming in. It would be childish to raise the question about middle age. But in the context of climate change, I wonder what age has to do with climate change. They're equally vulnerable, whether you're old or young or middle age, makes no difference. But again, that process of Christmas tree might have worked at somebody put in age. So it's a very important statement that is made by the preamble. Now I will come to the question of general question, apart from Paris Convention, in international environmental law, but also including Paris Convention, how far international IEL speaks to human rights. As we in human rights are the whole world. Human rights are everything and nothing. I often say there are as many human rights as many NGOs there are. So for every person, community. I've been fighting for the last 40 years against one human right, and fortunately I've succeeded. I tell you a success story. So far. That's what, it's all here. I've been fighting with several others against UN declaring human right to leisure. And who is promoting human right to leisure, do you know? International hotel company, airlines, because you have to travel to enjoy your leisure, and hotels, airlines, and local people who are running tourist resorts. So a whole idea is leisure, leisure means tourism. Tourism means industry. It therefore means sustainable development, right? Obviously. It means flyovers, it means better airports, if you take international tourists also, better airlines. So these are the lobby groups who said UN must declare a right to leisure. And I've been like a get-to-iters Chinese wall against that particular enunciation. So far I have succeeded. How long we will succeed, we do not know. Whether it should be opposed or not, I got a feeling it must be opposed. You may support it, I don't know. But my view is that it should not be human rights. In that sense, in senses which they do it. So, it is true, and I say somewhere, referring to Rajmani, no. The last paragraph. Raj Lavanya says, and it's written a very interesting article on human rights pressures upon treaty makers. Very interesting piece. I refer to it, my article, long article on climate justice, which by tomorrow you must have read, because it would be nice if you read it. Occasionally, no harm in reading Baxi, I can assure you that. Yeah? It's a good article. No harm. It won't certainly pollute your mind. It may do other things to your mind, but it won't pollute it, I can assure you that. It's the only article there is, basic article on climate justice, and I have to move towards that. That's the idea of the seminar. But Rajmani says the following: human rights approaches taken in their entirety have the potential to bring much needed attention to individual welfare, as well as to provide ethical moorings for, etc. So it brings individual welfare as well as ethical state. And she agrees, she therefore says this is more important in area of climate change. And she identifies human rights approach as, this is UNDP language, as benchmarks of progress. And Amartya Sen, my friend, has claimed that he has developed the UNDP index of human rights violation, which is worth looking at. You are far at the bottom of the India. Might be a superpower. As far as human rights are concerned, despite the jurisprudence, despite the Supreme Court, you are in the last 10 out of 180 countries. But we are the world's biggest democracy, of course. And we are biggest because we can't help breeding. That's not I don't think that is an achievement. But we take it as achievement. How did it become world's largest democracy? By producing children whom we can't look after. And we take pride in that. It's extraordinary. But that's how the world goes. We are the world's largest democracy. So the benchmark approach is UNDP approach. And she seems to be favoring it. And I have a lot of difficulty with that approach. I'll stated in my future human rights, and I won't. But I won't go into it. I want to draw attention to the great declaration, which is not May declaration. It's Malay declaration. I would not quote it otherwise. Malay declaration is a declaration generated by small island people. And the small islanders, very small, Bikini Atoll, smallest, or even little larger like Fiji or Nauru, they're all going to sink because they aren't irreversible. All of them are going to sink because the sea levels are rising. And avalanches are melting. Where would the water go? In the ocean. And the sea levels are bound to rise. I read the other day, by the way, and I don't know how far it is 100% correct or how far it is correct, that the Americans put a large number of nuclear weapons waste, large amount, in the glaciers in Antarctica under their control. And because of climate change, these glaciers are melting. And they will bring all the nuclear material, which is still very radioactive, right on the shores of various countries. when the ice and kill the life. So what happened in the 70s or 80s when the EU, Chernobyl, the Tea Party. Chernobyl sent a large number of shockwaves throughout the world. Even including Indian Supreme Court, I was a party to that adjudicated, I forget the name of the petitioner, a very important case on Hungarian butter. And it prohibited Hungarian butter because we argued it was contaminated by Chernobyl. They drew the water from wherever, and the water was contaminated. And we proved it. I also filed a petition against my colleague, the Vice Chancellor of JNU, because the workers were falling ill in the nuclear lab, in the physics lab, because of radioisotopes. And the Supreme Court ordered that the Vice Chancellor must put a notice board saying per parts billion what is pollution by radioisotopes, and should give the necessary gear to the workmen before you go inside the lab. So this Chernobyl will be a tea party when these glaciers come in. But anyway, what does Malay, and this is a real life. If we were in those islands, if you were being born in India, if we were born in a small island, you would think very differently. And the Malay Declaration says, and these are very important phrases, fundamental right to an environment capable of supporting human society and the full enjoyment of human rights. They are not picking and choosing rights. They are saying full enjoyment of all human rights. And they said climate change has clear immediate implications for the full enjoyment of human rights. Inter alia, among others, the right to life, property, right to adequate standard of living, cultural life, the right to food. So that matters to islanders. Where does the food come from? Right to food. And the right to the highest attainable standard of physical and mental health. Now look at their understanding of human rights and look at the Paris Convention preamble of values. That's why I put these two contrasting things. I'll come to that subject a little later. Now I come to a different aspect. It's a part of the seminars, namely the problem of intergenerational justice and climate change. And again, we have to ask the question, does the Paris Convention address this problem? How does it address the problem, if it does address it? And what ought we think ourselves as to how the problem should be addressed, no matter how the Convention addresses it, if at all. There are three different aspects. Now, as I said, Indians don't have any problem with intergenerational justice, because our courts give intergenerational justice only. Yeah.
Before we move on to intergenerational justice, could you build up on the fact of how it has been possible for the first world to water down the idea of corporate efficiency and responsibility to now taking corporate efficiency and responsibility and respective capabilities? How it has been possible for them over the years? The language has changed, as you pointed out. The obligation probably has changed. The idea of responsibility has changed and it has become more an idea of capacity now. So how and why that has been possible, why it has not been objected to in stronger terms by the third world universe?
Yeah, and every treaty is give and take. Every treaty is, as Sustain analyzed Kyoto Protocol, which I've done with you, but not cost-benefit analysis, whether it would cost you more, the particular country which is signing, or whether it will benefit you more. How will you monetize the costs and benefits? And in ozone, they supported Montreal Convention and made it a reality. And they prohibited aerosol manufacture. Right? In Kyoto, they did not even sign it. Now, Sustain is very careful to say that this is not how they actually reason in pence and dollars, but they can be interpreted to reason this way. Their actions are guided by other motives, but the cost-benefit method, how to avoid what is called in economic theory or game theory a prisoner's dilemma, how to arrive at a win-win situation is a major situation, major problem. So, so far any treaty is concerned, the national interest, so-called, prevails. When you come to climate change, interest in the planet not warming up is presented as common interest of all. So there is a universalization, let's say, of ozone convention, in a sense, Montreal Convention, a universalization, but through the Paris Accord. You can say that. But I didn't quite follow your other part of the question, which was about playing with human rights or
So my question was more to the fact that the third world, and by third world mostly I mean my question about India, because the thing is this, that the negative effect of the negative public opinion effect within one group country of this treaty not having been signed in Paris, had that happened, would have been much greater for the European Union vis-a-vis somebody like India. We could come back and no one in India would question much about it as a political issue. So why did the political elite of India go out there and have allowed everything in the older treaties to be watered down, whether it is the language of CBT or RC, or it is the fact that
how do you think it's watered down? The emissions are watered down, the national intended contribution.
Differentiation. The differentiation paradigm has been watered down by the use
Oh.
of the term RC. Because that takes away from...
If you see the movement from Kyoto to Paris, this is the important part, not from Montreal to Kyoto, but Kyoto to Paris. In Kyoto emerged this principle of CBDR and RC. And it emerged in Rio when they were the third world. I must be quite careful, very careful in fact, in dividing the world into global south and global north. There are different interests, national interests. The third world is not a homogeneous affair. When there were socialist societies, there was socialist third world and bourgeois third world. Now which is no longer the case, but apart from some states. Then there was a non-aligned third world and an aligned third world, who accepted the Monroe Doctrine of the US and voted with US, like Latin America. So there are variations within the third world. Then there is a third world that has now emerged of BRICS, which is participating in G8 or G20, and which says we are regional superpower and we should have a permanent seat in the UN. China already has, India claims that. And there are sympathetic noises about India getting the membership. So it's and they are the rest of the world. So third world is always heterogeneous. The idea of a treaty is to find, if you must use the word policy space, is to find an international policy space in which you can operate. Your interests are served, other people's interests are partially served, some interest to sacrifice, some interest to sacrifice, and you come to a... You have ever been traveling in train, and there's a Bicester, portmanteau. which you roll and then make it this big. Or sleeping bag is more favorite, more. You take a sleeping bag nowadays. So portmanteau is the treaty is several interests combined to produce a statement. Now you can read it as residing from the original position the third world might have, as a block. Or you might read it in terms of each country having a national interest and third world having a special national interest. And in Kyoto, carbon trading was enacted for the next two countries, which were global north. The idea of historic responsibility was recognized, and the idea of historic injustice was recognized, even by the developed countries, to produce Kyoto Protocol. Some of them did not ratify it, but you did. You countries did. So sometimes you act against short-term interests to get a long-term. If you study, you guys study intellectual property and TRIPS and all that. Now TRIPS is a very important area to study how treaties are made. What was the Indian position on TRIPS? What was South Africa's position on TRIPS? What was Zimbabwe's position on TRIPS? What was Botswana's position on TRIPS? You do not study this history. But common platform emerged in compulsory letters of license, in copyright field, in patent Article 7, I think, of TRIPS, which said in a case of public emergency, you pay the royalties, but you can take away the patents to the multinational. So some commonalities where aid is stressed, where cooperation is stressed, where funding is stressed, some commonalities are third world commonalities. But rest of the time, it's a negotiation of interests. I quoted Mr. Javadekar, the then Minister for Environment and Forest, yesterday, saying what he said. There is a great victory. And I quoted Obama saying it's a great victory. So a treaty does mark a shift in position, but this is, you must never forget, a framework treaty. The real obligations of the states will emerge between now and 2030. One important thing that Paris has achieved, and that is one nationally intended contributions. And India said 1.5%. The ideal was 2%, 2% part per million carbon you will not emit. But most nations agreed on 1.5. And actually it is more than 4 ppm outside, up there. So we are awfully short of environmental targets, but the nations of the world agreed to take steps to eliminate 1.5% of its emission. This compromise of the idea of the third world is in the process in IEL, Sustainable Development Precautionary Principle. If you study international environmental law carefully, the third world is the prime mover of some of these concepts. And third world negotiates its interest also through this concept. The Kyoto set up a special climate development fund, whose primary beneficiaries were Global South. And President Bush regularly said in his Senate and Congress, why should we pay money to these polluters? Why should we sign an agreement which creates a fund? We might have polluted the planet during the Industrial Revolution. We'll bring down now our share of emissions. But why should we pay China and India a climate fund, out of climate fund, to which we are supposed to contribute on Kyoto? So, whereas we receive those funds from the climate fund, I have not studied what to do with them in India or China, I don't know. But there is a third world resurgence on certain points in a climate negotiation. If you study how Paris came about. And there is a third world backsliding as well in interest of a common treaty. So it is not as simple as this or that, it is a bit of both. That's the kind of answer I would propose for your consideration. Is it right? Does this sound right? I wrote recently an article in which I copied myself, I'm ashamed to say. And I understand self-plagiarism is a kind of plagiarism. Is it? You say, shake me up. I plagiarized from an article I'd written on Third World Quarterly, partly, not wholly, which said what can the Third World expect from international law. But I built on that and said there is no more a third world. What exists is third worldism. The ideology of the difference between third world as a geopolitical entity is vanished. There is BRICS, there is this thing, the South Africa, India, there is China. Who would call them third world? They are the biggest polluters of the planet today. No matter what other people might have done earlier. The biggest polluters, 80% of the pollution of the ozone layer and of the climate, fossil fuel burners are us. Even in villages today, you'll find those cow dung cakes. Women who lose their eyesight cooking on cow dung or coal. I don't know, but the mess here runs on. Gas. All these things emit. Now, should you stop eating? Well, you can eat fruits, no? You can eat something or the other. You don't have to eat in the southern delicacies, dosas and Italy and bara. They require cooking. Every act of cooking, the smoke blows up. Either it is methane or carbohydrates. So, it is a tough thing. Now, I want to go to, if you kindly permit, I want to begin the discussion somewhat and ask you what can intergenerational IJ mean, or theoretically. I say we are all specialists in intergenerational justice because we decide the cases after a generation. It was remarkable that two judges decided the case of Judge Lalita so quickly, very quickly in fact, and restored the order of lower court, of the district court, sorry. The court is lower. Please remember that. Our constitution is most unfortunate when it's a part of judiciary, it says subordinate judiciary. It should be done away with. There is no such thing as subordinate judiciary. There is no doubt an administrative judge in the High Court who looks after the district court. There are district courts or grassroots courts, but I asked Yashwant Chandrachud when he was the Chief Justice, he was presiding over a lecture I gave. I don't remember what the lecture was about. But I said, Mr. Justice Chandrachud, I said, Chief, would you kindly tell the audience what is the difference, if any, between a Sarpanch and the Chief Justice of India? He said, what a question. I refused to answer it. I said, I'll tell you the answer. The answer is, there is no difference. A Nyaya Panchayat also decide disputes, territorially limited, and you also decide. Every judge is supreme in his or her jurisdiction. There is no subordinate judge. In fact, that they restore the judgment of the district court in Karnataka or wherever, you may be reviewed and turned aside. It's a matter of hierarchy, jurisdiction, hierarchy of jurisdictions exists, no doubt. But that doesn't make me, as a district judge, lower, subordinate in my judgment capacity. I'm the monarch. I can decide to hold somebody guilty or somebody innocent as I think the law stands. Somebody else might think the law stands a different way and can overrule me because they. So I don't think there is any subordinate judge. So I don't know why I came to that, but I came to that. Essentially, the problem of inter-industrial justice, IJ, is we ought to distinguish between, you got it? Oh my goodness, there is too much here. I can't find it. The problem of intelligent IJ is you are a duty to oncoming generations. We discussed that last a bit. How many generations make that duty? In climate change, I refer to John Rawls and earlier affirmative action, 3 generations. In climate change, we refer to infinite generations. There is a problem as to how do we know what future generations are, what they would want. We should certainly not put on more coal or more carbon dioxide in the air. That is agreed in our time, our lifetime. And we should find ways to minimize the greenhouse gases. We can't bequeath a planet even in more danger to future generations. That is clear. But beyond that, our, for example, family planning program determine who shall be born, who shall be the member of the society. It is decided by MRTP Act. Who shall be born? Membership of a community. Says the Indian law, best in the family, husband and wife, and they may decide to abort. It's a very good thing. It's how it should be. Women's rights are human rights. But ethicists raise this question, how can one generation determine the membership of a future generation? Can you? And there are difficulties, because who entitles you, as it were, to play God? The arguments on the other side of women's reproductive rights and rights for their bodies and of freedom, and you have to reconcile these arguments. So you've got some restrictions on abortion, but trimester-based or husband-based or family-based, whatever they are, and you can play around with this restriction. But the idea is a right is a space of freedom that is asserted by the Indian law. So you have a right to decide who shall be the future generation. In countries where abortion is allowed, and large number of countries allow abortion. Abortion means planned parenthood. And planned parenthood means you will decide who will be the next generation. So in a sense, the problem of intergenerational justice begins in this generation. Every generation decides whether I will be born again. I will be a member of this human species. If you abort me as a fetus, I can't be a member of future generation. Everything that is women's right over the reproductive rights for the body, right to do what they prefer. So there's a big dilemma. Leave it aside. In literature on IJ is decided, they analyze in three discrete ways. One is intra-generational justice. Justice within the same generation. Now, intra-generational justice is as important as intergenerational justice. That is justice of the next generation. And there will be a problem because we do not know what the next generation thinks. And I've kept up with young people, but I know what limitations they exist. They exist clearly. What you call the age gap or generation gap. Clearly. I mean, I don't like Western folk music. I like classical music. Young people don't like classical music. They like jazz or things like that. And the generation difference shows up in the examples, in the dress you wear, in the way you behave, the way you conduct yourself. So intergenerational justice is very important. And normally we think of justice in intragenerational terms. Then there is intergenerational justice, that is justice, and I won't look at this because I can't, time me up. Intergenerational justice, which consists of three generations, that we can reasonably speculate. Not fully know, but reasonably know. And that's very important for climate change justice. And the third is, in IJ as standing for indeterminate generations. Not three, but three and more. Infinite generations. Why? Because of climate change. The earth is going to be no longer habitable if the sea levels are going to rise, if desertification is going to increase, and you know it is increasing. If temperatures are exceptional, when it is winter it is summer, and when it is summer it should be winter. High floods, tsunami. When you know these things are already happening, many other things, glaciers melting, you can count a number of things even as I talk. Some way or the other, climate change has impact, an imprint. If this is the case, the question is, should we not worry about, should we not translate intergenerational justice only in intragenerational terms? That we can cope with. What you can do here and now to avert a future catastrophe. So some people say that in climate justice, building a climate justice theoretical approach, IJ is relevant, but the meaning of IJ is intragenerational, not across generations. For all that we know, this is the only generation we might have. Who knows? At the rate at which species are disappearing, it's now our turn of human species. It may not exist, I'm very sorry to say. If the ozone layer develops more holes again, then we all die of skin cancer. There's no escape. Or if climate change becomes more of a pressing reality. So some people say by IJ you mean intra-generational, what you can do here and now. Don't worry about future generations. Because there may not be future generations. The crisis is so serious. Some people say no, and these are sustainable development chaps, mostly, or affirmative action chaps who say, you must think of 3 generations. I do not personally think, because I have a poor apocalyptic, yeah? I got it right, apocalyptic imagination, which I criticized in the first lecture. I'm a doomsday person. What little I know of geology and geography and earth sciences, I think the party is already over. So I don't think we'll last till 3 generations. A very big question is, how many generations do we address when we build theories of climate justice? How many generations do we serve? I will be very surprised, and I hope sincerely that I'm proven wrong, that we will last, the earth will last for 3 generations. So you have to decide what, when you read Paris Convention, when you study IEL with our nice friend there, Sustainable Development friend, I don't know whether you are sustainable or not, but IEL people are. And I'm nothing against sustainable development, it's already past, time is past. So the question of what generations is very important. And I don't have a clue, although I wrote a wrong article. So what are the intergenerational tasks? And that's the task of, first of all, adaptation. How to discover alternatives to fossil fuel-based capitalism. What are the alternatives? How to decarbonize the economy? How do you think about degrowth? Again, the same themes which have some. Sustainable, if you like, sustainable degrowth. This is the task that each one of us ought to do. More specifically, you think of mitigation. How do you mitigate this impossible evil of total extinction of all species, including the Homo sapiens, including human beings? Regardless of your views on whether human beings should survive or not, on which I have no opinion. I'm puzzled sometimes by the thought that even if all other species die or are weeded out, human beings, being creation of a God, should survive. And we should always have a Noah's Ark ready. I think it's unmitigated anthropocentrism. But I go a step further and I say to myself, I should better keep it to myself, so pretend not to hear it. I often say to myself, so what if human life becomes extinct? There was no human life 50,000 years ago. The earth is much older than human life. There are other species. Human life is only 10,000 years old. Homo erectus appeared around 10,000 years ago. So I don't see any particular justification for human beings to continue forever as a species. In which case, as corporations tell us, you need not worry about climate change. And Mr. Trump may well be right. Because we want to disappear someday as a species, collective entity. The climate change, ho-ha, comes to an end. It's that sort of approach. But I think we ought to give our lemness best to say the earth goes on for some more time, so that we can go on. That's the short answer to it. And for that, first of all, we must develop measures of mitigation. And kindly look up Article 2 and Article 4 of Paris Convention. I won't discuss it now. Which speaks of mitigation in terms, ultimately, of reduction of greenhouse gases that you put in stratosphere. And India's contribution is, like most countries, 1.5 per ppm. They will reduce greenhouse gases. In their endeavor to reduce, they would reduce. And they would want alternate energy, which is means which are supplied by Western people. They would want them to be subsidized or free or whatever. And they would like to develop their own energy. There's an article on India and China in your reading list. Kindly read that. If I have time, I'll discuss it. So what are the issue is very urgent. Again, intergenerational, as I said, of small island states, which will certainly disappear. The mitigation in relation to small island states and peoples, not only in Pacific, but Andaman Nicobar, with whatever islands there are. I would even include in the list Britain as well. Divided kingdom, is it? Divided kingdom. United Kingdom, divided kingdom, your choice. Who ruled us for 200 years. They all island states, big and small, but big think differently, like Holland, like England. Sea level, when it rises, it does not make a distinction between who you are. It simply rises and follows you up. So, mitigation of climate greenhouse gases is a universally important task recognized by Paris Convention. Second is the, as I've said, the problem of climate refugees. And the 1951 Convention on Refugees, which says you can only seek an asylum if you are in immediate fear of your lives. Apprehension is the word used. Should go out, because that is, it is useful, but state does not prosecute you. They are the impersonal entity. So idea is, if a state prosecutes you, like Rohingyas in Burma, or minorities elsewhere, Burmas in Europe, or the civil war in Syria, these people can seek asylum. They have a right to asylum, human right to asylum, seek asylum, human right to seek, not to get asylum, in other countries. And there is a lot of debate which must be following about Syria and Mr. Trump and all that. I've said his name too often, I think. I should get out of that. And in fact, I must listen to our beloved Foreign Secretary, Mr. Jaishankar. Jaishankar has been renewed for 1 year by our beloved Prime Minister. And Mr. Jaishankar has said a wise statement, which is that we must not demonize Mr. Trump. We should understand how his mind works and take maximum mileage out of it. So there are two views already. The Indian government view of not calling a demon by a demon, and there is my view of saying we already know how his mind works. It's not a big secret. And intergenerational justice consists now of climate change and avoiding a third world war. The danger is very real. And what impact would it have on climate change? He already told Russians that he doesn't want strategic arm limitation. It's on phone with Putin for 1 hour. So if you don't want to manufacture more nuclear weapons in 2017, where would you use them? Defense production industries and defense establishment will generate a war. And this time it will be a global war in the name of X or Y or Z, that doesn't terrorism or whatever. the real full-scale war among nations, or led by nations, the real prospect now. And therefore, the question of climate refugees becomes even more complicated. And I'll deal with the, I don't have time now, you're tired, I want some comments, share anything. I will deal with the SDIs later. I've got them on your list, on your computers. How do small island developing nations feel? They think that Paris Convention was not necessary at all. The agreement among big states leaving us where we are. And the big states have been playing with us all this time. And Sri Lanka will disappear. Our neighbor, Bangladesh will disappear. So, they are saying we are disappearing. We are actually disappearing. There are 10 Solomon Islands which do not exist because sea has claimed them and they have been taken by elders in other islands. So, small islanders say we didn't want treaties at all, multilateral treaties at all. We need bilateral treaties. We need immediate action. We don't underburn all this language of Paris Convention. Paris Convention has gone to some extent to solve to massage the hurt of these people, and a number of reference to small island countries. But they are just, the dominant rationality is of the big states. It's not of the small islanders, never born. So there are interesting articles written, which I've given in my handout, looking at Paris Agreement from the point of view of SDIs. And one of the tasks of, that's my last word, of intragenerational justice is for the world to develop a capacity to deal with SDIs, small island developing countries, and with climate refugees. These are immediate happenings that will happen, and they are related. And I think, and this is my last, possibly my last word, I don't think the Paris Convention is really hospitable to this concern. But what happens between now and 2030 will be too late. Bangladesh certainly will disappear by 2030 or 40. So there must be a sense of urgency everywhere. And what we can do to harden this soft law of Paris is very important. Sorry, I spoke too long. I didn't allow you to interject. But you all look very tired. But if you still have any comments, I will. Yes, please.
Previously you spoke about how it is very difficult to link human rights with the question of climate change or climate justice. So I was wondering if it is even desirable to do so. So I understand for problems like climate refugee, the rhetoric of human rights may be useful. But in case climate change is linked with human rights, we do not think it will create a sort of balancing problem. So the kind of issues that we see in our own Supreme Court, everything is being linked to Article 21 somehow, even though we say that the right to clean environment is a fundamental right, somewhere we see that the Supreme Court gives greater priority to more established human rights, so to say, such as right to development or public policy priorities over things like clean environment or protecting the climate. So my issue is if we link human rights and climate justice, will not inevitably lead to a situation where things like right to development will be given a greater priority and somehow the whole idea behind protecting human climate will be lost somewhere in translation. Also, even if it is protected as human right, the problem will be how will it be seen as an individual, a negative individual right or a positive group right? So those modalities will also be difficult.
A very important comment. You know the answer to it. If you take the idea of IJ as intragenerational justice, then right to roti, kapra and makan, right to food, clothing and shelter, so-called social rights, assume a great importance, because today you must do justice to people who don't have a shelter, who don't have anything to wear, who don't have a house, who don't have food, who don't have health, who don't have education, elementary education, who wants computer, not computers, not given computer. It's an Indian made. In other words, all this talk of climate change, one view is, pushes this old human rights, the future of all human rights back. Because the main problem is presented as the problem of human extinction. It is no longer extinction of people who have rights and people who are rightless, in my view. Both sorts of people are going to be extinguished if human species. So one view is intergenerational rights mean there should be no more impoverishment in the country. Everybody must have universal minimum. There is universal minimum elsewhere in Europe, in so-called social welfare states. And the other side argues that even they are going to go away. The extinction as a problem is different from the problem of human rights realization. And if you don't follow the problem, if you don't have a jurisprudence or some prudence which will develop some theory, which will develop some strategies and arguments against extinction. So some people say it's more important to focus on extinction rather than development. It's old hat to speak about development of the underdeveloped. It's old hat. You've done enough of bakwas on that. So let us now let's change the subject of bakwas and talk about jurisprudence of extinction. The book which I have, Madam Colebrooke, I forget her first name, it is there in the at will readings, I think. Colebrooke, Essays of the Post-Human. People who are subjected are likely subject of extinction. And from that little book, I gather this idea of jurisprudence of extinction, because I'm a limited person. Limited pa, not son. I'm somebody's son, but I don't know. Biology. One can be biologically male, but culturally female, and vice versa. So, some people say, worry about extinction. Human rights come only when you solve the problem of extinction. Your strategy is to cope with extinction. When human beings exist. So some people will say, think about climate change justice. How states behave in regard to climate change is the main problem. How do they fight extinction? Fight the Paris extinction properly. Or the Kyoto did properly. Don't worry about human rights. Some other people say what you say. That you worry about human rights, even as you worry about extinction. Now, can you write two horses at the same time? This equestrian question. But some people do. And in this serial, I don't know if you watch serials or not, but the Star Plus serial, you can almost do anything. There's a Nandini serial, Chandragupta serial, at 8:30, in which Nandini can do miracles. She can hang on the trees, she can ride 2 horses at the same time or 3. So, I mean, we must be wrong. You can probably become a Nandini and you can do human rights and extinction together. I was called by no less a person than Richard Prof. Just 5 years ago. Richard was in Delhi, and in the full assembly, I made no kind of point. That we should not worry too much about climate change, we should worry about looking at the makan of these people who don't have anything to eat, drink, or shelter, education, etc. And immediately classified me as a climate change denier. So there are climate change hawks and climate change doubts. Now if you know anything about species, difference between hawks and doves, there is a big difference between hawks and doves. So the hawks tend to believe the only thing that is real and that matters is climate change and extinction. And once you've sorted out that problem internationally, nationally, regionally, then you can go back to all this Article 21 or Article 8. Or you have institutions which will anyway do it, continue doing it. Supreme Court will, I think, never turn its back against judicial review. It's a done thing. It will be in business. It also, Green Tribunal will protest against Maharishi in Bangalore. Yeah, Sri everything, God, Bhagwan was. The Green Tribunal find it, nothing happened. The event was there, the floodplain to Yamuna are part of this stuff. So, some people say it's a duty to only pursue climate change and extinction. Some people say you can pursue both, and you'll be Nandini of the world. And some people say you only pursue human rights, forget about extinction. Now I know I have my view, but they did not, that have to be your view. That's the whole point of this stuff. You have your own view. And my views are very clear that you must give priority to extinction. What Paris does is to say you must give priority to extinction in accordance with human rights law and jurisprudence. This is not possible in India. I don't even do with Nandini, Princess Nandini, Prince of that place. So, kindly do look at this figure if you've not watched it. It's a Hindi, unfortunately, Sartras. I call her Dudraji, but she is married to Chandragupta Maurya. It's a very interesting figure. You will learn some jurisprudence from it. You can look at the climate change. Now, if you follow Nandini, you have no problem. That's my shortcut. You can ride as many horses as a rider as you want. The ride is perfectly okay. But if you think otherwise, that is the problem. Yeah.
So my question is, so whatever view you take, does it also not depend upon where you understand the source of rights to be coming from? So let's say I assume that human rights exist because human rights equality is central to all. Then in that situation, those human rights and let's say the problem of extinction have like a similar basis. Because I'm saying rights are important because life is important to everything, and that is why we have to solve the problem of extinction. My other problem is that if you say that the problem of solving extinction and the problem dealing with extinction and climate change should be above even the concern of human rights, does the problem there not become that if you keep aside human rights, then problems which existed, which have led human rights to become so important, are going to be the ones dictating how you solve the problem. For example, let's say, so if you say that you have to deal with climate change above everything else, and then we say, okay, then to help with the right to equality, then wouldn't it, let's say the problem of men dictating the discourse, or let's say the majority dictating the discourse over like the needs of the minority become like a real issue?
That's a very interesting point of view. I think certainly that's what Paris Convention does by bringing certain human rights instruments and by excluding others as being relevant to climate change. One can take that view and say, why not all human rights? Why only some? And so on. Or why age as a signifier of vulnerability? Why children and old persons? What about young persons? Will they all be swallowed up? So we can quibble with it, and you can make a suggestion in the next 20 years to all. So there's certainly human rights there are people who believe that human rights have a great deal to do to help our fight against climate change. There are people who believe it, and I think it's a reasonable point of view. But they don't tell us how. This is the problem. And my problem is not with the idea. My problem is the mechanism. Now I talked in the first seminar, and I just bring your mind back to it, to biology and human rights. Remember that the very first day on Sunday we talked about, you might have forgotten, which said a biologist does not understand the expression human rights. The life scientists say there is a law of natural selection, survival of the fittest and all that. You can't explain evolution by human rights. And you can't ask the question, does the crustacean have a human right? Artificial intelligence, although I'm a member of a society in California, a privileged member of rights of artificial intelligence. You have video games where you can kill. They are knowing you are killing program. None moots about the rights, human rights of artificial intelligence. All the places in MIT law schools, I did that. They asked me, so I did that. And there is a very great rights of the planets. Now, biology says it's all nonsense. It's only there are certain illusions that human beings must have in order to live. And human rights is one of these necessary social illusion. The idea of rights is a necessary social illusion. So there are those who, and you romanticize the illusion and make it larger than life and you make it matter. That's the job of human rights. As if human rights provide solution to majority, bulk of problems, social problems. That's a very important question. And whether human rights do or do not, how long do they take, it is intergenerational or intergenerational. It's a very big problem. Some rights are, it took us 60 years to write a constitution, 60 years of freedom struggle. So how many generations? 2.5. Or maybe even 3, 82. Mutiny, 4 generations, 1857. Depends on where you start. So, some rights are what are called in literature as manifesto rights. Rights that are to be achieved in some distant future, directive principles. They are rights, social and economic rights, but they are achieved by hit and miss, by trial and error, sometime or the other. And some are achieved here and now, like Part 3 rights, where you can file a writ. And you can shuffle your cards. Put ek dil ka tukra hazar hua, koi yahan gira, koi wahan gira. But you can put some in the directory principle, some in fundamental right, do it. Play that game under 21 of incorporating directory principles into rights. I tried to pretty try. Who has it is an empirical question. Antula had it, but does the ordinary person have it? I doubt. But that you can decide yourself when you read the Constitution or whatever. So, yes, rights are important, but there are many, many rights. And rights are the great thing you have to remember about human rights, that human rights are always in conflict. Sri Ravi Shankar and my beloved Prime Minister, Mr. Modi, said there's a right to culture. And therefore this festival must go on. And floodplains of Yamuna will not be disturbed. It's all a superstition. There is a right to religion, the right to free speech. So, rights are inescapably in conflict. And put together this right conflict with climate justice. Because right is a space of freedom. You can do anything you like with your property. That's the idea of property. Now climate justice would say you can't put the carbon as much as you like into atmosphere, stratosphere. You can't use fossil fuels. A time will come when it will say you can't use the carbon footprint involved in air travel. Imagine how much of carbon dioxide an airplane generates, up 5,000 feet. So it is, when they are in conflict, climate justice should have a certain way of solving the conflict or adjusting the conflict. Merely saying human rights is not a magic wand. You can't just wave it. The human rights always in context and human rights always in conflict. No human rights conflict is mine. As a young person reminded me in the law school, I used to have pipe smoking. He said, in Washington College of Law, I went there because founded by two women. Now my first overseas assignment was in Washington Law College. And they of course did not know it, I knew it, so to research. And the two lawyers in late 19th century who gave all the money, and that's the American College of University of Law exists. American University exists, Washington College of Law. And so in a sense, why did I mention it, I forget now. In a sense, the idea of, I forget the linkage, I have not tried to bluff you into one, but I would say, I really forget, it's surprising, which shows I'm tired, or non-compos mentis, whichever. You cannot possibly show me a single right. Yes, in Washington University, a young woman told me, I offered a research course, and one of the research course was mass disaster and on torts, on law of tort. Torts, market versus justice. That was the title. Research course, anybody would come. And my idea was to prepare an American lawyer who would fight my Bhopal cases. Unfortunately, I found two, and one was of Indian origin. So he was very helpful. And he did this course on Bhopal himself with my guy. The other was a woman who was anti-tobacco person. I used to smoke a pipe. Very difficult to light the pipe, and I were inseparable. So I could not light the pipe in the snowfall outside the building. I was trying to light the pipe. And she had enrolled from my course on Mast Road. And she said, I'll have nothing to do with you, Professor. You are smoking. And I'm an anti-smoking advocate. I said, my usual answer is, I'm burning a multinational tobacco. I'm actually burning it after a while. She said no, and she disenrolled from my course. Later on, of course, now my doctor said I shouldn't smoke, so I don't smoke. But they're buying the story. I found that my right to smoke ends where your nose begins. And I also found that the world is a very nosy place. You cannot possibly smoke because the world is full of noses. And if your right to smoke ends where your nose begins, one can never smoke. But that was the Washington story. So rights are always in conflict. But rights are also freedom to do what you like. Freedom, absence of regulation. Rights are an opportunity. Rights are a border. Rights are resources with Ambani and Adani of the world. And rights are closure. They close your world. So rights are many things. So you must have an idea of rights, an idea of human rights, and then we can talk. I think certainly you can take the view that human rights instruments, and that's the view that Human Rights Council took. And that's why you are in the preamble of Paris, for the first time, that it matters to have human rights. But I don't think human rights put together have, or constitutional rights or equitable rights, there are very many types of rights, have faced the problem of human species extinction. And therefore rights talk takes our minds away from that problem. It is valid, valid in its own location, and it will continue. But the problem before us is a different problem of mass extinction of humanity and species. And we need new necessary social illusions, other kinds of social illusions to cope with it, not necessarily human rights. That's my thinking as of now. But have I provoked you? Yes. You look provoked.
It's often pointed out that the burden of climate change is borne by particular communities, populations that are more vulnerable at this given moment, whether it's indigenous communities or the burden of today's kind of capitalist society and its manner of functioning. Marginalize certain communities, and they're the ones that bear the costs of this way of functioning as well. And a lot of what we speak of in the context of human rights also speaks to these communities and their minority status or the oppression, historic oppression of the communities and so on. So what I was thinking was to take the specific example of smaller nation states that usually find it difficult to find greater voice in international arena, or indigenous populations, or people with disabilities and so on. Is it possible to conceive of any theory of climate justice that does not in fact address these existing injustices? And if it does, then maybe we don't speak the language of human rights, but wouldn't we be incorporating the substance of at least some of those ideas
Absolutely.
into a theory of climate justice?
Absolutely. There is a lot of substance in the language of vulnerability. I think human rights are rights which are necessary because one is vulnerable to power. of the other. So one wants freedom, then you want human rights necessarily as a space against that vulnerability to power. So Paris Convention does that very ably, I think. It speaks of vulnerability and it gives some examples of women, children, etc. But I'm guilty of giving you a static picture of climate change. I mean, extinction is a reality. But if you look at the other narratives of climate change, which are not state narratives, which are not narratives of modern day NGOs, I was reading a book by a woman, of course, called Adventures in the Anthropocene. And it's available in India. The woman's name is Gaia, but I think an adopted name. Gaia is Mother Earth, so obviously it's Gaia something. And you must read that book. For example, she says how people in Ladakh have been fighting through local wisdom against glaciers. The glacier is a big problem. It's not only an Anthropocene problem. So people have found ways in local communities, without state mediation or without NGO mediation or civil society mediation, in their local community, how they have averted some of the dangers of extinction already. Now to them, Paris Convention would be new. They would say, what is this? What is it? They don't know anything about sustainable development, precautionary principles. They don't know anything about law. But they find their wisdom in their people. And this book is 300 pages throughout the world she has traveled and collected anecdotes. And she calls Adventures in the Anthropocene. It's a paper. It's hardly 300 rupees. You must buy and read that book, and your world will change. People have been addressing the problem of extinction long before it was recognized as a problem for the world. People in Ladakh, many other parts of the world, have First Nations people said umpteen examples to deal with Mother Earth concept. So, the question is, there are narratives of Anthropocene and there are narratives of human rights. Their ability, their disability to change things. And we only get narratives of the apocalyptic of doomsday imagination. We get narratives of scientists, the glaciers are melting, everything is going to end, extinction. From geographers, from nature scientists, and so on. We get narratives from treaties, Paris Treaty is a big change. But people in their own way, in a locale, have found ways to deal with what you now call Anthropocene. They have lived with it and they have found ways to avoid extinction. And this book tells you is a delightful book. So the problem is, from which perspective would you approach Anthropocene? Whether you approach it from the point of view of local wisdom or international wisdom, of which human rights is a part. But extinction is also a part. So there are various narratives of the Anthropocene and various